Hello and welcome to Financial Sense. My name is Jake Szulinski and I am a financial advisor with Edward Jones Investments here in Wayne, Pennsylvania. And our goal on this show is to help educate our local community, mostly about financial topics. And today with me, I have Laura Tobey from Reidenbach Law, and we will be talking about estate planning. Laura, thank you for being with us today. I appreciate it.
Thank you for having me.
So Reidenbach Law, right here in Wayne as well,
Absolutely.
local.
Yep.
I want to start off by learning a little bit more about you.
Sure.
And how you got into law, and of course how you got started in estate planning.
Sure. I grew up in Wayne, so it's great to practice where I grew up. My mother was a lawyer, my grandfather was a lawyer, so I guess I always had that interest. And during law school and after law school, I really enjoyed helping people with their estate plans and setting up their legacy for their family members for years to come.
Great. That's great. The million-dollar question, why an estate plan? You know, why is it important?
Yeah,
I mean,
absolutely.
I know that's probably a very loaded question. We're going to go down a lot of
Sure.
subtopics underneath of that.
Sure.
But why does somebody need an estate plan?
Sure. An estate plan helps you decide where your assets go. So you've worked your whole life, you've amassed some wealth, you may or may not have children, you may or may not have charities that you care about. When you have an estate plan, you get to say where your assets go. And in addition to just a will, then if you become incapacitated, you get to decide who takes care of you or makes your health decisions or end-of-life decisions. So that's why you have an estate plan.
Absolutely. So you kind of alluded to something there. So if you don't have an estate plan,
Correct.
there's some possibilities that things may not go the way you want them to go.
Absolutely. Unfortunately, I've had some clients who either delay or don't think about getting a power of attorney, and then they become incapacitated through health reasons or otherwise, and they have to have a guardian appointed, and that's a very lengthy, invasive, into your privacy process.
Sure.
And you have to go to court and have someone officially appointed your guardian.
So you don't even really have a say at that point because you're most likely incapacitated,
Yeah.
or not, maybe not even around, and you're going to have a guardian that somebody else is appointing for you.
Correct.
Yeah, that sounds a little messy.
Yeah.
How does somebody really get started on this topic? So if somebody says, okay, well, I'm listening to your talk today, or maybe they read something and they say, I really should look into this. How does somebody really get started with an estate plan? What's kind of the first steps?
Sure. So for me, I have a questionnaire that I have my clients fill out about their assets, their family members, their structure, and we take that and I analyze that, and then we set up an initial meeting to go over what your goals are, who your family members are that you trust that are appropriate for certain positions, and then from that we draft the documents, review them, and then go through the whole process to the end where we do the signing and the witnessing and the notarization.
Okay, so starting at the 30,000-foot view and
Yes.
figuring out, I guess, you know, the
Narrow it
big
down.
questions. Yeah, who do you want as beneficiary on certain things,
Yep.
and all that kind of stuff. How many different options are there inside of an estate plan? I mean, I know I work with tons of clients around certain things like just your pure, straightforward wills, power of attorneys, health directives. How often do you see people branch away from that and maybe look at things like trusts or other, you know,
Sure.
riders, for lack of a better term, that you can add on to an estate plan?
Sure, and I've done the whole spectrum of estate planning. A lot of people have testamentary trusts in their wills, which spring from the trust after your death. Some people set up revocable trusts. I've dealt with special needs trusts for special needs children. And I have done codicils for people who just want to change a little tweak in their will. So it really is tailored to that specific person, that specific family, and what their goals are.
Okay. And I kind of breezed by this, I think, when I mentioned it. Are those kind of the three main places where you start? Is that will, power of attorney, healthcare directives?
So there's four.
Okay.
We do four. We do the will, we do the general power of attorney, which is the financial power of attorney,
Sure.
healthcare power of attorney, and then the living will for the end of life decisions. We also do often with financial advisors the beneficiary counseling, where we make sure those non-probate assets, your 401ks, your IRAs, have the designation that matches what you want in the will.
Yeah, so let's dive into that real quick for a second. So you said that term non-probate assets. So one, can you explain probate versus non-probate for
Sure.
everybody out there?
So a probate asset is an asset that's in your name alone. So perhaps your car, a checking account that you own, those would pass via your will.
Right.
Anything that's joint with your wife
Right.
or even a child, that would pass to the surviving joint owner.
Right.
Or you have the beneficiary designated accounts where you fill out a form either online or on paper that designates who you'd like it to go to.
So like you said, the 401ks, maybe the investment accounts like I have with a lot of my clients, you fill out that document, you specify somebody on there, and that's who it would go to.
Exactly.
Now, let's talk about that. So let's say that I specify Laura as my beneficiary on my 401k.
Right.
But in my will, maybe I say it's going to pass to my neighbor Joe.
Yep.
You know, I would like him to have it. What happens there when you have a conflict between those documents?
Sure. What happens is the beneficiary designation overrides the will. So that's why you have to make sure to have them match and be going to the same place, or even if you did want that one to go to Laura and the other one to go to Joe, that's okay. But that's something that an estate planner would look at to say, by the way, you haven't looked at this 401k or this IRA in 10 years. Do you know it's still going to this person? Which is often the case with divorces.
Of course,
you forget to change it after you get divorced.
Yeah. I agree with you. I've seen that a lot with divorces, and even when you're adding to the family. So you have, you know, extra children or something, or maybe that wasn't something planned, and you know, you forget about adding those to the official documents.
Yeah, and I've reached out to clients after they've had other children, been like, by the way, we didn't. You know, you said you only wanted this child. We should probably add all of them. But there are also ways that we can accomplish that in the beginning, where if clients don't know if they want more kids, or to leave it open-ended so that everyone is included. Down the line.
To say all my children or something like that. Okay, that makes sense. All right, let's take a step back out. We got into a little bit of the weeds there, but when does somebody start thinking about the estate plan? So again, you know, we talked about, okay, first step, maybe get a hold of somebody like yourself, doing a little research, filling out these questionnaires. When should somebody do that? Is it at age 18 when they become an adult? Is it later on in life when they accumulate assets? What's your recommendation there?
That's a good question. For a lot of my clients, when they have 18-year-olds, I recommend that they get a general power of attorney and a healthcare power of attorney, especially if they're going off to college. Because if they're going off to college, something happens, you won't be able to have access to your child's documents, even though you might be paying for them to attend said school.
They're a quote-unquote adult, but we all know how that works with helping the kids out. Absolutely.
Exactly. So those are documents that I definitely recommend for 18-year-olds. They don't necessarily have enough assets in most cases to need a will. But I would say definitely when you get married, when you acquire a major asset in your name, and definitely you want to revise all these documents, as you said, with the birth of children, divorces, deaths, inheritance, etc. Exactly.
Yeah, okay. That makes a lot of sense. So let's say we keep throwing it around here that when you acquire an asset or something like that, is there usually a line of demarcation of wealth of when you need it? Or, you know, if somebody, you know, doesn't have as much, when does that come into play?
I don't have a set number for that, because I can tell you, even the people who pass with what some would consider a small estate, if you don't have an estate plan, somebody needs to still step up and say, I will make sure all these debts are paid, the taxes are paid, that the monies go to the relatives. So it's always good, even to do a very small estate plan. You don't have to necessarily get into all the bells and whistles of trusts and so forth, but to appoint these people to assist you if something were to happen.
Sure. Then you kind of mentioned it there, changing the plan. So again, our lives change every day. You know, well, I mean, again, the last year of this pandemic has shown us that frequently. You said when there's a life event, you really want to look at those documents, birth of a child, maybe you know, if there's a divorce or another marriage or whatever it may be, you want to make sure you look at that plan. If nobody has that, if everything is kind of sailing smoothly, how often do you recommend people looking at their documents and maybe sitting down and revising some of the verbiage that's in there?
I would definitely recommend to look at it every couple years.
Okay.
Again, maybe it's not a major event, but maybe the person that you appointed, maybe they had something change in their life, or maybe you're not friends with them anymore. So it's just good to reread the documents and say, yes, this is still my wish.
Right. That makes sense. In forming all those wishes, I know you said you talked about going through the goals of what those clients are. Some of the main goals that come to my mind are, of course, one, who's it going to, but also maybe trying to limit taxes or doing other things to make sure that, you know, who I want it to go to gets the most of it as well. How much do you get involved with that when looking at avoiding some taxes legally, of course?
Sure, of course.
And making sure that all lines up with what the client wants.
We do work in concert with financial advisors about that. And also we have some flexibility in the documents so that if one spouse passes and the other is still alive and they need to put some money into a trust because it's more advantageous for taxes, because Congress changes the laws every couple of years, set to again in a couple of years. So we do have some flexibility, and we do look at that as well.
Okay, let's dive into that a little bit. So again, as our lives change, me and you know very well that, like you said, Congress can change some things around, especially when it comes to estate taxes and inheritance. Right now, we are in Pennsylvania, so let's talk about Pennsylvania. I know this can differ from state to state.
Yep.
But we're talking about two different levels of inheritance tax. We have the federal level and we have the state level.
Correct.
Can you explain that a little bit more to me?
Sure. So for Pennsylvania inheritance tax, you are most likely going to pay a tax.
Okay.
For spouses, it's 0%. For children, it's 4.5%. And then it continues for siblings, and then friends and charities are also 0%.
Okay.
And then I think right now it's 11.4 for the federal inheritance tax rate that you don't have to pay until you pass that much per person. So it would be 22 and change for a couple.
Okay. So hypothetically, God forbid something happens to me and I leave it to my spouse, there's no inheritance tax.
Correct.
But if either me or my spouse go at the same time, my spouse is no longer around, I want to leave it to my children. Now we're talking about at the state level, 4.5%.
Correct.
At the federal level, I would have to have over 11 point something $1 million to my name before the federal level estate tax kicks
Exactly.
in. Okay.
Yes.
And then so if me and my spouse are both still living, what happens if we go at the same time? Do we get a combination of those 11 point something million on both of that? Or is it still 11 point something million for?
It would be 11 million point
Right.
whatever, so the 22 million together.
Okay, gotcha. So you get it to group it together.
And another reason why you do an estate plan is when I write my wills, it says that the tax is paid from the estate first. So you collect all the assets, you pay the taxes, then you disperse. So it is not the beneficiary's responsibility. The estate handles the tax and then gives it to the children.
To do that. Got that. So we are looking at a change possibly coming up in the next couple of years. Any thoughts on what that change is going to look like? I believe it's going to revert back to the old rules.
That's what they've been talking about, is that it's going to revert to a lower number.
Okay. So obviously that's maybe a triggering event for some people to say, hey, well, maybe I don't have 11 point something million, or me and my spouse don't have 22 million combined.
Exactly.
But if it does revert to a lower number,
Sure.
what is that lower number going to be? And of course, we'll see, I guess, once Congress gets done with it. But that may be something, hey, if we're pushing up near that number, or we expect to live a little bit longer, it's probably a good reason to sit down with somebody and review that plan.
Absolutely.
What happens, so let's take a step out of the estate and kind of go back to the power of attorneys, because we talked a little bit about those. Having those in place before something happens is obviously the best way to do it, because most of the times it's usually an emergency.
Yes.
When somebody comes incapacitated. So let's talk about that from two different angles. What happens if there is an emergency and you do and don't have a power of attorney? How does that work when trying to go through those motions?
So when you have a power of attorney, say I'm your power of attorney, something happens to you, I use my document, and then I can go and sign on your behalf, pay your bills. If it's a medical issue, I can authorize medical procedures for you.
Gotcha.
Without that, there is no person that anyone can go to, and you would have to have someone appointed, and that can take months.
Then that goes back to that guardian that you were talking about earlier.
Exactly.
Okay.
And as I've had happen, if there's a possible issue there, the court will appoint a lawyer who does this to then oversee you. So now it's not even a recommended or family member that you would anticipate being your guardian. It's now a lawyer for a period of time who I'm sure will do a great job. But again, this is not the person you would have chosen if you'd taken the power in your own hands.
And the timing of that, as you stated, could be way longer than what's actually needed.
Absolutely.
I guess especially when you're talking about medical and things
Exactly.
need to get done, but even financial, there's obviously bills that are coming in every month.
Yes.
And that's extremely important. So when we're looking at power of attorneys and beneficiaries, what is the best way to kind of review that? Do you go to each institution? Do you ask them for copies? How do you usually have your clients gather that information to actually do a review to make sure things are going to the right places and the right people are assigned?
Absolutely. A lot of times clients, after I give them the questionnaire, they say, how often should we update this? And having done my own estate plan, I try and do it every year, just because you do change where your assets are, et cetera. And having a document, and I work with financial advisors who sometimes will provide their own internal documents, which is very helpful, because then you have it in two places, with your lawyer and your financial advisor. And then when we do the beneficiary counseling, that's where we coordinate whether it's online, whether there's a form that needs to be done. And so there's a lot of work to coordinate everything and make sure that we have all the pieces.
A lot of moving parts and pieces. So let's take the worst case scenario and go back to it, talking it from a beneficiary standpoint. Let's say that, again, somebody is looking at our talk today, or they do their own research online. They say, something really important that I should probably look at, make sure everything's lined up the way it is. And let's say they just never get around to it. You know, we're very busy again with what's going on, and people with their lives and a lot of things happening. If they forget and they don't have somebody that's listed on these accounts, what happens then?
Sure.
And they don't have a will. I'll preface that as well. They didn't get the will done, and they said, well, at least let me get my beneficiaries on there.
Sure.
And that just never happens, and God forbid something happens to them. Where does that take us?
Sure. And without getting into the details, because the intestacy statute is complicated and needs to be read for each individual circumstance. It all depends on whether you're married, whether you have children, whether you have parents, and it goes down a list of priority as to who gets what. And the trickiest situation is if you're married, no children, but your parents are alive, because then the estate will get split with your spouse and your parents, which is probably not what most people intend. Some people may, but some people usually people want it to go to the spouse first and then their children if they have children.
I want to repeat that because I want to make sure, because that is important. That is something that most people probably don't realize. And first of all, the term that you used was the intestacy statute.
Correct.
So intestacy is when you
pass without a will.
Okay,
if you
perfect.
pass with will, you are testate.
Gotcha.
Without, you are intestate.
Exactly. Perfect. So if we pass without the will, and I am married but have no children.
Correct.
And I pass away, my wife will not get 100% of my estate if my parents are still living.
Correct.
Okay.
In Pennsylvania.
Yeah, that's probably a big thing to, again, have somebody probably trigger to say, well, I should probably have something in place.
Yeah.
So these statutes are made up, and like you said, they are going to differ depending on your marital status. If you have kids, and I'm assuming it even gets more and more complicated when you have kids from multiple marriages,
Absolutely.
mixed families, things like that. But there is that published out there somewhere?
Yes.
To go and look at that? Okay.
Yes.
And again, I'm assuming it's probably not going to line up with 99.9% of people that look at it.
It usually is not exactly the way you would want things to pass.
Yeah. So it sounds very overwhelming, of course, because there's all these different ifs and buts and what could happen. I know we talked about kind of the first step is filling out these questionnaires, but if people are feeling overwhelmed, is that kind of the first step, is to reach out and try to just talk with somebody, whether it be a financial advisor or estate planner?
Absolutely, because I try and explain the process.
Right.
And I think generally I have to say it 2 or 3 times because it is a long, complex process. But my goal is to focus on the questionnaire, focus on what your assets are, and then we have a talk about your family and your beneficiaries and who's responsible and who will take care of you and who will handle the estate the way you want it to be handled. And then by the end of the process, we have everything in line, the signing is easy, and then I generally create an e-portfolio, an e-copy of everything that I give to the clients, and then we keep their original documents in our vault.
That makes a lot of sense. We touched on it a little bit, but the blended families. So obviously that's a very complex situation. What do you usually see when you go down that route? How do you usually handle that when you have multiple marriages, kids from different marriages? I know you have these processes, but what does that kind of look like if somebody comes in and has those kids from different...
many clients like that.
Sure.
It's the same process. It's a different result usually.
Okay.
A lot of these families sometimes have prenups. So the prenup is important to take a look at and see if they have waived, because in Pennsylvania you cannot disinherit your spouse.
Right, I've heard that before. So even if I wanted to say, okay, me and my spouse are married, I really like my neighbor Joe, I'd like to leave him everything that is in my name, we can't do that.
Correct.
Or if I do that, it's probably going to come back after I'm gone that there's some type of formal legal proceeding that will not
they
allow me
can
to do that.
claim an elective share, which is 1/3 of certain assets.
Okay.
The other thing relating back to your blended family is you may have 2 families who each have like a husband and wife who each have 2 children, and they've agreed to give it to their children. So if they have a prenup and they're waiving this elective share, we don't have a problem.
Okay.
If that's not in place, we can do a postnup where we rectify this issue so that no one is claiming anything, because everyone's on the same page anyway. So we're just cleaning up a potential issue.
Sure.
And then that can be done. but sometimes they do want to leave things to each other. And even if they have a prenup that says, I waive everything, you can write a will and leave things to your spouse, and that will supersede the prenup. Sorry.
Right. No, that makes sense. Again, a lot of moving parts and pieces, and it's going to lead into my next question because I get frustrated a lot when I hear this because I think people just don't know what they don't know, which is, hey, Jake, I do my taxes on TurboTax. Why would I not just go and buy some software for $50, $100, whatever it may be, and just write up my own will? And I can do it right through the software. I go get it notarized for free down at the bank or wherever, at the post office, and I'm good to go, right? So what?
Yeah, without naming any of those names. The problem that I've had is that I will get these documents that people have tried to do themselves, and then I talk to them about what they intended to do, and it's not what actually results, because you're not talking to someone who has done hundreds of these documents. It may just be a program. I do believe they may have someone available to answer questions, but this is a form, and forms are not interactive. They don't ask you questions. They don't make you think about the personalities of these people and oh, this person is my firstborn, but the thirdborn is actually the more responsible one. So it's good to have someone with experience and to interact to make these decisions, in my opinion. Okay.
No, I appreciate that. It's great. All right, so let's talk about, we kind of talked about the formation leading up to having that plan in place. Let's talk about the more, unfortunately, morbid part of this is after something happens. So, you know, again, we talked a little bit about what happens if we pass without a will, but all right, we have the will. You know, everything is set up kind of the way we want it. What do my beneficiaries and heirs have to look forward to, or, you know, again, my executor, executrix have to look forward to process-wise after I'm gone? If everything is kind of set up, let's just say the right way. You know, we sat down with you, got everything in place, something happens to me, now what?
So that process is much smoother than if you have to go to court and have someone appointed. It's just quicker because you have the documents. You can get the will probated, which is not a scary process in Pennsylvania. Some states it's very difficult. Pennsylvania it's not. It's simply swearing that you will follow the will and pay the taxes, pay the bills, and deliver the monies to the designated beneficiaries. I work with executors all the time. I ask them to help me gather all the assets, all the bills. And it usually takes about 9 months is when the inheritance tax return is due. And then it takes several more months for the government to approve it. And then we get a clearance letter that says everything was done properly, and that's when you can disperse monies. You can disperse monies to the beneficiaries before then, get a receipt and a waiver, but usually it's best to hold back some monies in case the government wants additional taxes.
Right. So what hiccups do you usually see when that happens? So somebody, again, you know, that's fine, great. I did everything I was supposed to do while I was living, got everything in order. Are there things that usually pop up that you see, or no? Is it usually a pretty smooth process?
It can be a smooth process. It's difficult if the assets were not in order, so we don't have a clear idea of what a decedent owned. And so we have to do some digging. I've had some issues if the executor is struggling with their responsibility, either due to emotional reasons or it's just not their forte. And I'm always here to help, but again, you need participation.
Of course.
I think those are the major issues. So it's really important, as relating back to what we said, is to kind of have an idea of what your assets are. And I've had clients just give me an updated, here's the spreadsheet, and so I include it with the file, so that if something were to happen, I can look back and say, this is a starting point for us.
Absolutely. So again, I've said it a few times, I think there's so many moving parts and pieces, there's so many ifs, ands, and buts, that I think that's probably my main takeaway from talking to you and from working with you previously with my clients, is that if you need to get a plan in place. I mean, that's number one, is to at least sit down, put pen to paper, and at least have some type of goal, like you said, or some type of plan in place, and then go from there.
Yeah, and I don't think it seems overwhelming, but if you find someone that you feel comfortable with, that is competent, I think they can guide you through this process and make that easier and alleviate that burden. And at the end, you're like, I'm so glad I did that.
Well, Rome wasn't built in a day, so we know that this is not something you're probably going to flick the light switch and say, okay, I can knock this out overnight. It is a little bit of a process, but like you said, I think the ending of that process is definitely going to justify all that work that you put into it and getting it done. Well, that's great. Laura, I really appreciate your time today and your vast wealth of knowledge
Thank
in
you.
this. I always enjoy working with you. If people want to get a hold of you, the best way is to go to reidenbachlaw.com
Sure.
and reach out to you. I think your email and contact information that we will be able to put up here.
Yep.
All right, perfect. Again,
you so
thank
much.
you for your time. I appreciate it.
Thank you.
Thank you, everyone, for joining us on Investment Sense today. I look forward to seeing you next time. Thank you.